Hi, I'm Carrie Rinker. I'll be lecturing today on part 2, Counseling the Local Food Movement. I lectured on part 1 last month, and 2 months ago I lectured on how to start and build an agriculture law practice. So this is part 3 of a 3-part series here at Lawline. If you're just tuning in today, I highly suggest to go back and revisit my previous 2 lectures. For those of you that don't know me, I grew up on a beef cattle farm in central Illinois. I actually have an associate's degree in agriculture from a junior college near my hometown. I went on to get a bachelor's in animal science from Texas A&M and a master's of science in ruminant nutrition. I bet some of you listening to the podcast today did not know that you could even get a master's in beef cattle nutrition, but you can. And then I went to law school at Pace Law School, which might make sense on how I ended up here in this part of the country. I received certificates in environmental law and international law. After graduating from Pace, I worked as an associate at Bud Fallon Law Offices in Cheyenne, Wyoming, which is the windiest place in the country. I did environmental law, property law, land use, and federal lands litigation. I was working with cowboys, all over the West, and at some point I got homesick for New York City and I decided to move back here and hang my own shingle. I currently have my own food and agriculture law practice based here in Manhattan. I am the chairperson of the American Bar Association General Practice Solo and Small Firm Divisions Agriculture Law Committee. That's a little bit of a mouthful. And my client base ranges from farmers to ranchers, small to mid-sized agribusinesses, and increasingly food entrepreneurs. So people making jams and jellies and mustard out of their home possibly and wanting to sell it in their community. Today I'm going to be talking about a whole slew of legal topics that affect the local food movement. In part 1 of this series, I talked about the overview of the local food movement and went into detail about a USDA article about the local food movement. I also talked about cottage food operation law, direct farm marketing, liability, and liability insurance. Today, I'll be delving into some different topics, including the Food Safety Modernization Act, the National Organic Program, direct meat marketing, on-farm poultry slaughter, agriculture districts and the right to farm law, urban agriculture such as backyard chickens and apiaries, and then we'll close with volunteer farm labor. So we'll touch upon some employment and labor law. We'll begin today talking about the Food Safety Modernization Act. For those of you that are not familiar, it's sometimes pronounced FSMA. It was signed into law by President Obama on January 4th, 2011. It's the first major update on food safety law in the last 70 years. I can't believe it's been that long since we've had a substantial update in this area. It shifts the focus from responding to contamination to preventing it, or at least that's the underlying goal of the statute. So it changes our system to being reactive to proactive. This is still in limbo. So today I'm going to be talking about the proposed rules that were published in January of this year, January 2013. We're currently awaiting the final rules. The proposed rules, the comment period is still going on. In fact, it was extended and then it was extended again until November 22nd. So of this month, the FDA will still be taking public comment. Today I'll be lecturing, of course, on the proposed rules, which are, of course, subject to change. The proposed rule mandates the establishment of 2 primary regulations that we'll talk about here today. One is the produce rule, and the other is the preventative controls rule. Let's start with the proposed produce safety rule. It establishes science-based minimum standards for safe growing, harvesting, packing, and holding of produce on farms. The proposed new standards regulate new areas for the FDA, such as worker training, health and hygiene, of workers, agriculture, water, biological soil amendments, of animal origin, domesticated and wild animals, equipment, tools, and buildings. Farms will fall into one of three categories under the proposed rule. They're either exempt completely from the produce safety rule, they might be subject to modified requirements, or the full requirements. And you will see this in both of the proposed rules here under the proposed regulations. So the FDA kind of got rid of this one-size-fits-all and are now saying that farms of different sizes are subject to different levels of regulations. So what kind of produce is applicable here to the proposed produce safety rule? Well, most fruits and vegetables in the raw state. And what does raw mean? It means unprocessed. So if you have a carrot, the whole carrot, that's raw. Then when you chop it up, it is now processed. Some exemptions for this rule are fruits and vegetables that are rarely consumed raw. For example, potatoes. When's the last time you bit into a nice raw potato? Doesn't really happen, right? They're usually cooked or fried. So fruits and vegetables that are rarely consumed raw would be one exemption. Another one would be if it's produced for personal or on-farm consumption. A third exemption is if it's destined for commercial processing. Examples include canning, bagged salads, and leafy greens. A farm is completely exempt from the proposed produce safety rule if it averages annual sales during the last 3 years of $25,000 or less. And keep in mind here that this is sales, not profits. So for farms to fit under the complete exemption, then they really have to be pretty small. Modified requirements occur. The produce will undergo additional commercial processing that kills harmful microorganisms. Then the produce is not covered. However, the farm will still be subject to record-keeping requirements and the compliance and enforcement requirements of the produce rule. In terms of sales, who are we talking about here? Well, the farms that were exempt had $25,000 or less in sales. For the modified requirements, we're talking about farms that in the last 3 years had at most $500,000 in gross annual sales. So technically it's $500,000, less than $500,000. They also have to be selling their food to a qualified end user. Who is that under the regulations? Well, it's a consumer, a restaurant, or a retail food establishment. If that's the case, then the farmer fits into these modified requirements. One of the requirements includes that they must provide the name and complete address of the farm where the produce was grown on either a food packaging label or a sign at the point of purchase. So if they're at the farmer's market, they need to have the name and the complete address of the farm they're having a sign. Let's move on to the second part of the rule, which is called the Preventative Controls Rule. And again, this is still just a proposed rule. In this situation, the court's going to look at whether or not there's any manufacturing or processing activities that took place. Remember, I just gave the example of the carrots. The carrots are cut up, that's processing. So is any kind of chopping or slicing, canning, drying, artificial ripening, cooking, pasteurization, infusing, distilling, salting, smoking, etc. These are all different forms of manufacturing or processing. The FDA will also look at the type of manufacturing that takes place and whether the farm is using its own agriculture products or somebody else's. Are they buying fruits and vegetables from another farm and then creating jams and jellies? Or are the fruits and vegetables grown right there? There are some reduced requirements under the proposed regulations for farmers that are using produce from its own farm and then manufacturing or processing it. The proposed rule under the preventative controls rule has two main points. One is the hazard analysis and risk-based preventative controls. For those of you that are familiar with HACCP, or the Hazard Analysis Critical Control Points, this is the same type of concept that's now being applied to fruits and vegetables and different types of produce. The other the other part of this rule is good manufacturing practice requirements. Now keep in mind that some facilities are going to be subject to only one, but not the other. So it's important to keep the two of these requirements separate in your mind. So who's subject to the hazard analysis and risk-based preventative controls? Again, the FDA in the proposed regulation breaks it up into three different categories. Farms who are exempt. There are going to be farms who are going to be subject to modified requirements. And then there are going to be farms that are going to be subject to the full requirements. So where will your client fit in? Who's exempt? Well, the following products are exempt. Juice and seafood, for example, and that's because we already have HACCP. We have juice HACCP and seafood HACCP. Dietary supplements are exempt. Alcoholic beverages are exempt. Low acid canned foods. Grain elevators and warehouses that solely engaged in storing agriculture commodities or packaged food are also exempt. Small or very small on-farm businesses that conduct certain low-risk manufacturing and processing, packing and holding activities such as making jams and jellies or manufacturing honey and maple syrup are also exempt. So who's subject to the modified requirements? We've got the same threshold here again. We're going to look at the previous 3 years and see if they hit that $500,000 mark or more, and if they're selling directly to a qualified end user. That doesn't just mean a consumer, it also can mean a restaurant or a retail food establishment. And if that's the case and they are subject to some modified requirements, again, they still have to display a label or sign with the complete business address of the facility at the point of sale, perhaps a farmer's market or wherever that they're selling. So who's subject to good manufacturing practices? Almost everyone. The only facilities that are exempt are warehouses and grain elevators that store raw agriculture commodities, including fruits and vegetables intended for further processing. And we're not going to go into detail today on these good manufacturing practices. For those of you that practice in this area, I suggest that you review the proposed rule to familiarize yourself with those. Part 2 of today's talk, I'm going to talk about the National Organic Program. I pulled a lot of this information today from an article written by Harrison Pittman. For those of you that are not familiar with Harrison, he is a great contact in the agriculture law community. He works for the National Agriculture Law Center down in Arkansas. And the National Agriculture Law Center is also doing a fantastic job providing education to people in the agriculture community and agricultural lawyers. Just last month, they gave a presentation on country of origin labeling. I'll be giving a presentation for them in January on farm and ranch leases. So if you can, go ahead and take a look at this article. I think it's a great resource. In way of background, Congress enacted the Organic Foods Production Act in 1990. The purpose was to basically say, we want to develop consistency, we want consumers to know what organic means, and this is to facilitate interstate commerce in fresh and processed food that is organic in nature. The Organic Food Production Act directed the U.S. Department of Agriculture to establish national standards for organic production. Now, we didn't get these standards until about 10 years later. I can't believe it took that long, but it did. So these standards were set forth almost 13 years ago in December 2000. USDA finally published the final rule that created these organic standards. And it is also administered, importantly, by the USDA Agriculture Marketing Service. So AMS is the sub-agency of the USDA that handles the National Organic Program. As of October 2002, a producer or handler must be certified organic, must comply with these standards if they want to sell a product that's organic. And a lot of people don't know this. I teach at NYU, and my students were pretty dumbfounded when I sent them off to go talk to organic farmers. They thought that everyone at the farmers market was organic, and that's not the case. So there's a specific program, and I think that in and of itself is important, that if a client walks through your door and they say, we want to sell organic food, we want to market it as organic, that is, they need to comply with the National Organic Program. There are exemptions. The first is if they are a handling operation that has a gross income from sales totaling $5,000 or less. That is not a typo. That is, it's only $5,000. So we're talking about very, very small farming operations, maybe somebody with a garden who occasionally goes to their farmer's market or sells to their neighbors and things like that. These people are going to be exempt from some parts of the regulation, not everything. This is primarily for producers that sell direct to consumers. They don't have to. They could also be selling to indirect markets. They still must comply with applicable organic production handling requirements, but they do not have to submit an organic system plan. And they also must comply with the labeling requirements for exempted operations, meaning they can't be used in the USDA label, and they cannot be used as ingredients in processed product identified as organic. Here's another exemption: a handling operation that only handles agricultural products containing less than 70% organic ingredients by total weight. This might be a middleman, like a manufacturer. Here's another exemption: a handling operation that identifies ingredients as organic only on the information panel only. I'm not lecturing today on food labeling law, but for those of you that are not familiar, the principal display panel is what you see at the grocery store. If you buy a box of cereal, the principal display panel is on the front. The information panel is on the side. That is where you're going to have the nutrition facts or the supplement facts if it's a dietary supplement. You'll have the ingredient list there. So that's what we're talking about. And in this picture, I actually have an ingredient list from organic dog cookies. And there's a point to this, that we all think about the National Organic Program as it applies to people food, but we're also talking about animal food as well. There are two main exclusions, so get this separated in your head from exceptions to the National Organic Program certification. One is handling operations that sell only organic products that are packaged or otherwise enclosed in a container before the operation receives or acquires the product. So it would be like a grocery store. It comes to the grocery store, it's already packaged as organic. Another would be a retail food establishment that process on the premises raw and ready to eat food from products that were previously labeled as organic. Importantly, whether an operation needs to be certified, whether they are exempt or excluded, they have different record-keeping requirements. So it's important to counsel your clients on the various record-keeping requirements, because for certified operations, they can be quite onerous. Certified operations must maintain records that relate to the production or handling of agriculture products sold or labeled as organically produced for 5 years beyond the date the records are created. The records must include a detailed history of the substances applied to the operation's fields or agriculture products, the names and addresses of the persons who applied the substances, the dates and rates the substances were applied, and the methods used to apply these substances. Whew, that's a mouthful. They must also be sufficient to demonstrate that the operation has complied with all the NOP requirements. So when the certifying agent comes and knocks on the door, which they might, Those records must be available during the normal business hours of the farm, and they must prove that the farm is in compliance. For those operations that are exempt, for example, that farm that grosses no more than $5,000 a year in sales, and again, we're talking about sales, not profits, they still must maintain records sufficient to demonstrate that the ingredients were organic. But these records are only need to be kept for 3 years, not 5, only 3. And they still need to be made available. From a practical standpoint, these farms are rarely audited unless there is a problem. But nonetheless, farms are recommended to go ahead and comply with this record keeping requirement. And for those excluded operations, like the grocery stores and the retail establishments, it's confusing and unsettled right now. The comments state in a relevant part that each exempt, excluded, and certified operation should maintain the records which demonstrate compliance with the Act and the regulations applicable to it. So they should still be using records, but there's not, it doesn't say on how many years, etc. So there's still some ambiguity on what needs to exactly happen. All right, we're going to move on to allowed and prohibited substances, methods, and ingredients. So certified operations that are selling organic food, they must handle the product without the use of synthetic substances or ingredients unless it is allowed on the national list. And I was looking very recently at the regulation with the national list is quite long. And my students at NYU went out to go talk to farmers, organic farmers, certified organic farmers, and this was the biggest complaint that they had, was that they felt that the national list was too long. Too many things are allowed. Nonetheless, it is important to, if you are working with clients in this area, that they be alerted to the national list, what's on it and what's not on it. Certified operations must also produce and handle products without the use of prohibited non-synthetic or non-agricultural substances unless they are again on the national list. Keep in mind that there are certain vaccines, for example, that can be used for limited purposes that are on the national list. These organic farmers cannot also use an excluded method. What's an example? Well, one is with GMOs, genetically modified organisms, and they cannot influence their growth and development by means that are not possible under natural conditions. I know that GM labeling is a controversial and divisive topic right now in the food and agriculture community. Some argue that we already have a label for non-GMO, and it's the organic program. Before learning about this topic, I was not familiar that this was actually a requirement in order to be certified organic. So no GMOs in organic. But importantly, excluded methods do not exclude the use of traditional breeding practices that take place on farms, or in vitro fertilization, which is like artificial insemination, like if embryos are extracted from a cow and the in vitro fertilization happens in a petri dish. So this can still be considered an organic practice. And there's an important thing that I wanted to note with this is that, I grew up in production agriculture on a beef cattle farm, and we have been using traditional breeding selection since, my whole life, and agriculture has been using this for decades and decades and decades. So it's important to understand that there are some things as far as technology and sorting with both phenotype and genotype that are certainly allowed even in the organic food production system. An organic system plan must be submitted to the certifying agent. And so I keep on using this word, certifying agent. Who are these people? Well, these are people that are authorized from the U.S. Department of Agriculture. It's not the USDA themselves. In New York, an example of one of the certifying agents is NOFA, the Northeast Organic Farming Association. So if you would like some more information on certifying agents, you can go to USDA's website, or I suggest even contacting NOFA. So this organic system plan needs to be submitted to the certifying agent. What is this? It is a plan of management of an organic production or handling operation that has been agreed to by the farmer and the certifying agent, that includes written plans concerning all aspects of the agriculture production or handling operation. Put simply, it is written proof that the farm is going to comply with the National Organic Program if they follow the terms in the organic system plan. It also needs to include record-keeping procedures and, of course, needs to describe management practices. As far as the land is concerned, any field or farm parcel from which harvested crops are intended to be sold, labeled, or represented as organic, they must not have any prohibited substances for the previous 3 years. So if a farm wakes up tomorrow and decides that they want to be certified organic, they can't be certified organic immediately if they have used any of these prohibited substances in the last 3 years. They also need to have these boundaries or buffer zones, which a lot of farms do have these boundaries or buffer zones. But the important point here is that the organic farmer actually has the onus to prevent prohibited substances from entering their field. So if a neighbor farm is using prohibited substances, the onus is going to be on that organic farmer to keep it off. Okay, and they do that through these boundaries or buffer zones, such as runoff diversions, to prevent the unintended application of a prohibited substance. Under the soil fertility and crop nutrient standards, a producer must select and implement tillage and cultivation practices that maintain or improve the physical, chemical, and biological condition of the soil and minimize soil erosion. A producer must also manage crop nutrients and soil fertility by rotating crops, using cover crops, and applying for plant and animal materials to the land. I didn't know this until recently. A producer must use organically grown seeds, annual seedlings, and plant stock in their operations. There are some limited exceptions to that, but generally speaking, they must use organic seeds and seedling. I grew up in Illinois. Crop rotation is a big deal to maintain the soil fertility in the land. In black dirt country, we grow a lot of corn and beans. So an example of this would be when a farmer would rotate corn and beans. Corn takes a lot of nitrogen out of the soil, and then beans the next year puts the nitrogen back in. So a certified organic producer must implement various crop rotation practices. They can't be planting the same thing year in and year out. And I do have citations, by the way, on the corner of the slide, so for those of you that want to go back and read the regulation itself. As far as livestock production is concerned, livestock basically needs to be managed according to the regulations in organic management conditions. And what these conditions include and don't include vary depending on the species. And I'm not going to go into details about that. But what's important to point out is these conditions must be maintained on the last third of gestation or hatching. But there are 3 exemptions to this. One is poultry. It's from the 2nd day of life forward. Another is with milk production. Dairy animals must be maintained in organic conditions with 1 year of organic handling. And then breeding livestock is from the time of birth. And breeding livestock is the type of cattle that my family raises. All right, with livestock feed, No, so keep in mind here that the feed itself also needs to be organic, that's fed to the animals. But this doesn't just mean grass. I think a lot of people confuse grass-fed and organic. Organic doesn't mean grass-fed. You can still have organic beef that's grain-fed. And another thing I wanted to point out too is that a concentrated animal feeding operation, or a CAFO, can be organic as well. So I think a lot of people think that these, if you're organic, then you're definitely not in a feed yard or a concentrated animal feeding operation, and they definitely weren't fed grain. That's not the case. These are different programs under the USDA, so try to keep them all separate. But if they're fed grain, hay, silage, or whatever, they still must be compliant with the National Organic Program and be an organic agricultural product. The National Organic Product also looks at the health and well-being of the animals. It's actually required to establish and maintain preventative livestock health care practices under the National Organic Program. For example, they must administer vaccines and other veterinary medicines when needed. They must allow for exercise and freedom of movement and the reduction of stress appropriate for the livestock species. Essentially, they need to accommodate the animal's natural behavior. Now, what happens when Hurricane Irene comes or Superstorm Sandy comes? Well, farms can seek variances, temporary variances, to be precise under certain circumstances from the various requirements under the statute and national organic standards. So this happens when there is a natural disaster caused by drought, wind, flood, excess moisture, hail, tornado, earthquake, fire, or other business interruptions. But we're essentially talking about acts of God with these temporary variances. Let's move on to labeling, which can sometimes be confusing for a consumer when they sometimes see the USDA certified organic label. Sometimes they don't. Sometimes they see 100% organic. Sometimes it's just organic. What does all this mean? Well, there are 4 main labels with organic. One is 100% organic. Number 2 is plain Jane organic. Number 3 is made with organic, fill in the blank, made with organic peanuts. And the 4th are with products with less than 70% organically produced ingredients. And these percentages are determined by the weight in solid form. All right, 100% organic. It means it's 100% organic. And this, so it's not 99.9, it's 100%. And products in this labeling category may display on the principal panel, on the information panel, and on any other panel of the package that the label is 100% organic. And they can also use the term organic to identify the various ingredients. They can go to town, it's 100% organic. Number 2, plain Jane, organic. This means that it's basically 95% or more. So it's 95% and 99.999. And then number 3, labeling made with organic blank. This is for multi-ingredient products that are comprised of at least 70 to 95%. So they fit in that little between 70 and 95%, and they can essentially state that one or more of the ingredients are organic. So an example would be if you go to the store and you buy a candy bar and it advertises that the candy bar is made with organic peanuts, then you know that at least 70% of the ingredients in that candy bar are organic, and they just happen to be bragging about their organic peanuts. And the final one is with 70% organic ingredients. In this situation, there is no USDA label. This is for products with less than 70% organically produced ingredients, and they must have been produced and handled in accordance with the organic production and handling requirements. So no seal. I like this little chart here, kind of breaks it down a little bit. So to summarize, we've got the 100% organic, and they can use the fancy little USDA organic symbol. If they just have organic, they can still use the USDA organic seal. And remember, the percentage is 95% or more. If it wants to brag about some organic ingredients and say made with organic something or other, then in this situation, it's between 70 and 94% organic. There's no USDA label. And on the ingredient panel only, and this is at 70%, is that they're going to list some of the ingredients that were organic. And if you remember back to the slide with the dog label, the cookies, the ingredient list had different ingredients that were listed as organic. That would be an example possibly. All right, so if a farm comes to you and they say, I want to go through the National Organic Program, I want to get certified, just to give a brief overview of the process, they've got to obviously comply with the standards. Some of the standards that we've talked about today, some of them that we have not. They're quite voluminous. I would certainly try to familiarize yourself with them and talk to your client about their production practices. As I mentioned, they're going to have an organic system plan. They're going to have to sit down with the certifying agent and develop this, and it needs to pass muster with the certifying agent. The certifying agent actually needs to come onto the farm to handle an inspection. This isn't just a one-time event. This is going to happen on a regular basis, annually, biannually. They also need to maintain records. They need to make payments to the certifying agent. Have to pay the piper. The person must also notify the certified agent when there is an application of a prohibited substance or change in the operation at all. So if a farm doesn't comply with all of these different standards, their certification could be suspended or revoked. There could be civil penalties up to $10,000 per violation. So there are certainly some ramifications if a farm doesn't comply with the National Organic Standards. Let's move on to direct marketing of meat products. This is a publication that I found through Cornell Cooperative Extension Small Farm Program. They have done a phenomenal job here in New York, having very substantive publications for farmers. This is one of them. It's about 100+ pages long. It is quite substantive. I would recommend checking it out online. In way of background, we have a Federal Meat Inspection Act, okay? Which, when cattle are slaughtered here in the United States, they're usually slaughtered at a USDA inspected facility. That means the FSIS, the Food Safety Inspection Service, has an inspector that's there on site, okay? Making sure that, that the plant is compliant with the federal law and regulations. So, animals are separated into two different groups. They're either amenable or non-amenable. Amenable animals are answerable to the Federal Meat Inspection Act. This includes cattle, sheep, goats. Amenable poultry include chickens, turkey, ducks, geese, guineas, ratites, which includes ostrich, emus, etc. Non-amenable animals are not subject or not answerable to the Federal Meat Inspection Act. That includes game animals and birds, even if the farmer raises a domesticated species of that animal. So I know some farmers in Texas, they raise deer, okay? So, or rabbits might be an example of this. So game animals that are domesticated are still considered non-amenable animals. So these slaughter facilities need to comply with FSIS regulations. And even imported meat needs to pass these various inspection requirements. FSIS sends inspectors out to different countries and make sure that these slaughter facilities meet the U.S. standards for meat slaughter, okay? And so we don't just take meat from anywhere. And so I just wanted to point that out. And all right, there's a big exemption to all of this, and that's for custom slaughter. And an example of this, and this is a photograph of me in circa 1999 showing cattle at the Illinois State Fair. My family would typically would actually kill R4H projects, and then we would eat the hamburger and the steaks throughout the year. Like, this is an example of a custom slaughter. So this should not be confused with state slaughterhouses that are inspected by state officials. This is for the owner themselves or their household. The meat, when it came back from the locker, was stamped, not for sale, not for sale, not for sale. So this is an exemption to all of this, is custom exempt slaughterhouses. Non-amenable slaughtering and process facilities, and we're going to go back to what that means. It means non-answerable to the Federal Meat Inspection Act. There are specialized state facilities that conduct butchering and processing for non-amenable animals. So in New York, and we're going to talk about Article 5A licenses in just a few moments, but these facilities would need an Article 5A license. Or if you're in Wisconsin, I'm sure that they have another license there in Wisconsin. So it's going to vary from state to state. And typically, these state facilities actually have higher standards in some areas than custom exempt plants. Like, for example, hot water needs to actually be at 180 degrees Fahrenheit versus 170 degrees Fahrenheit. All right, so the topic of this section was selling meat direct to the consumer. So what does all this mean? In New York, all red meat from amenable species must be slaughtered at a USDA inspected facility. Some states allow for state inspected slaughter facilities if sold in intrastate commerce only. Poultry is a whole other ball of wax, okay? And I have another publication from Cornell Cooperative Extension Small Farm Program, but also the publication that was listed in the earlier section on direct farm marketing also talks about on-farm poultry slaughter and Article 5A licenses that I recommend. I recently authored a book, a field manual, it's a legal guide for New York farmers and food entrepreneurs. I have a whole section or a whole chapter in that book on this topic as well. But I highly suggest reviewing the Cornell Cooperative Extension publications. The general rule with poultry is that it must be slaughtered at a USDA inspected facility. And this is under the Poultry Product Inspection Act, the PPIA. But there is a big exemption to this, and that is the 1,000 bird exemption. So I have New York as an example, but this is actually an exemption that's listed under the federal statute. So if a farmer has 1,000 chickens or 250 turkeys, then they're exempt from the statute, okay? But one turkey is equal to 4 chickens. So if they've got a hybrid, maybe they have 50 turkeys and 800 chickens, and they're still exempt. There are some additional requirements here under this exemption. These chickens and turkeys must be actually raised on the farm. They can't be going out and buying these turkeys and chickens from other people. They actually need to be slaughtered and processed under sanitary conditions, practices, and procedures that are sound, clean, and not adulterated or misbranded. That's a big mouthful, and we're not going to be going into the details of those sanitation requirements today. But that is certainly a big one. The poultry producer must keep required records, and the poultry cannot move in interstate commerce. In talking about local food law, The word interstate and intrastate, those concepts come up quite a bit because a lot of these exemptions are basically only applying to food that stays in intrastate commerce. And if you remember, if you were here at the last presentation, I talked a little bit about cottage food operations and how if you're making homemade jams and jellies, and in New York you can do that, but it needs to stay in intrastate commerce. You can't be selling it on the internet. And it's the same concept that applies here as well, is that we can't be moving across state lines. Dealing with places like New York City farmers markets, where on a regular basis people come from they come from New Jersey and they come from Connecticut and they shop perhaps at a New York City farmers market. That's where intrastate and intrastate commerce, in my mind, started becoming a little fuzzy. There's not a lot of case law in this area at this point in time on this. But back to the 1,000-bird exemption. The slaughtering and processing must be done on site. So they either do it in their backyard or in a shed, or they have their own poultry processing unit or the mobile processing unit. And there's some photographs of what that might look like. With this 1,000-bird exemption, an important point is that it is per farm, it is not per farmer. So let's have an example of a farm family. They have a general partnership agreement between them. They are sharing profits. So whether or not they knew that they had a partnership or not, they are sharing profits. Grandpa has 400 chickens on his farm. His daughter has 200 chickens. His two sons, who are roommates, they live together, they've got 400 chickens, and a grandson who has 100 turkeys. The farm enterprise in that situation is not going to be eligible for the 1,000-bird exemption. So, per farm, not per farmer, and that can sometimes be blurry in farm families because sometimes people form partnerships and they don't even know it. So look at the fact on whether or not they are sharing profits to determine whether or not a general partnership has been created. The New York State Department of Agriculture has recommended that poultry that falls under this exemption be sold direct to consumer. They don't have to, but it is recommended. They still must comply with food labeling requirements, such as the product name, the inspection legend, and establishment number, the net weight statement, the name and address of the farm, and the safe handling statement, which looks a little bit like this. This is something that I do as a lawyer, is I also just make sure that the label is compliant. So that's something that you could think about. If there is a nutritional claim that is made, then a nutritional facts panel must be included on the label. I'm going to move very quickly through these processing guidelines, but if you are working with clients who fit under this exemption, make sure that they are aware that there are very specific processing and sanitation guidelines, good manufacturing practices, standard operating procedures, and the hazard analysis critical control point plan. If you recall, I was just talking about this under the Food Safety Modernization Act. So this is an example of when it can be used here on the meat side of things. All right, Article 5A licenses. I know that some of you might not be in New York. I'm calling it Article 5A because it's Article 5A of the New York Agriculture Markets Law, but it's highly likely that you have an analogous statute in your state. In New York, if a farmer harvests more than 1,000 birds, yet stays in interstate commerce, or maybe we're just dealing with non-amenable species, then this farmer does not have to harvest poultry at the USDA inspected facility if the farm obtains an Article 5A license. Okay, so if they fit under the 1,000-bird exemption, they don't even have to get the Article 5A license. Here are some additional exclusions under that, and you'll see the 1,000-bird exemptions listed. The custom slaughterer, if the farm is using the meat for their own farm and household. And a fourth exclusion is if any farm who donates the poultry to a charitable or not-for-profit organization. Here's another exclusion for Article 5A licenses. This diagram is pulled from the Cornell Cooperative Extension publication on direct farm marketing. But Article 5A licenses, they're a 2-year license, $200. The New York State Department of Agriculture must be satisfied with the equipment and the sanitation procedures that are set forth. The New York State Department of Agriculture may inspect the premises at any time. A drawing, such as the one that's here on this slide, must be submitted and including the specifications of the facility. And the inspection results must be posted on the premises. We'll move on to land use and zoning. Something that I'm asked about a lot is the right to farm law. What is the right to farm law? Well, the first question is what is an agriculture district? Because it's all connected. The New York State Constitution actually encourages the development and improvement of agriculture production. I'm not sure, for those of you that are not in New York, I'm not sure whether or not your Constitution has a similar provision, but I like to see this, that the New York State Constitution has a provision with this. Article 25AA of the New York Agriculture and Markets Law basically states that local governments, when exercising their powers to enact local law, that they should do so in a manner as may realize the policy and goals set forth in the article and shall not unreasonably restrict or regulate farm operations within agriculture districts. Okay, so what's an agriculture district? An agriculture district is land that has historically been used for agriculture practices. If an owner wants their land to be in an agriculture district, there is a formal process, a public process that needs to take place in order to identify that land as an agriculture district. There are a lot of advantages in having land be identified as an agriculture district in New York. And some of them are that there are exemptions, such as SEQR. The State Environmental Quality Review Program doesn't apply. And they are exempt from some building codes and building constructions. Put simply, farms located in agriculture districts in New York should be free of overly restrictive land use regulations. How does this all come together with the right to farm law? Nearly every state in the country has its own right to farm law, and New York is no different. New York has a right to farm law. Right to farm laws bar nuisance suits against farmers who are using sound agriculture practices in agriculture districts. So question 1, is there an agriculture district? Question 2, are they doing a sound production practice? If that's the case, then no nuisance suit. The complication with all of this is that there is no definition per se on what is and is not a sound agricultural practice. It's the New York State Department of Agriculture that basically has a say-so over this. NYSDAM may consider the operation of farm equipment, proper use of agriculture chemicals and other crop production methods, the direct sale to consumers of on-farm products, agriculture tourism, and importantly, the New York State Department of Ag may consult with the U.S. Department of Agriculture and/or Cornell Cooperative Extension on trying to decide whether a farm is using or whether they are doing a sound agricultural practice. If NYSDAM is asked if a farm is doing a sound agricultural practice, they will then publish a notice in a newspaper in a surrounding area. This farm is not, and this is why. if a farm is conducting a sound agricultural practice on land in an agricultural district, and importantly, this is also subject to an agricultural assessment, then this farmer is not considered doing a private nuisance. They cannot be sued for a private nuisance. NYSEM also makes a determination whether these local laws are unreasonably restrictive for the farmer that is conducting a sound agricultural practice as well. So that's another component. Importantly, we have a right to farm law at the state level, but what it basically says is localities, you should enact this at the local level. Agriculture is important to our state. So ultimately, the power is held with local law on whether or not this right to farm law exists. Okay? Here's an example of what it might look like. Nothing contained herein shall be deemed to limit the right to farm as set forth in Article 25AA of the New York State Agriculture Markets Law, and then it might say, go on to say, if the farm is conducting a sound agricultural practice in an agricultural district. So that's usually how it works. We have a really cool mediation program in New York. Not every state in the country has this. Most do. New York is one of them. But right to farm disputes can actually be resolved for free through the New York State Agriculture Mediation Program. It is funded through USDA dollars, and this program takes two kinds of disputes. One is right to farm disputes. So if you have a neighbor who is complaining of a farm that's smelly, they can actually commence a mediation with NYSAM. I'm sorry, the NYSAMP. I have my abbreviations incorrect, the New York State Agriculture Mediation Program. The second type of dispute that this mediation program works with is USDA Federal Farm Program disputes. So like crop insurance might be one, or FSA loan programs might be another. I am actually a mediator that is on the New York State Agriculture Mediation Program list. I will get paid through USDA dollars to mediate these types of disputes, not very much. And for those of you that are listening on the podcast today, if you are interested in also being a mediator that's on this mediation roster, go ahead and email me. You do need to be a trained mediator with the Community Dispute Resolution Center in your county in New York. For me, that's New York County. I was trained through the New York Peace Institute. Moving on to a slightly different topic under the genre of land use and zoning, backyard chickens, hot topic right now in urban agriculture. This is really found in local zoning law. You're not going to find this in agriculture markets law. This is, you're really wanting to try to hone in on the zoning law that's there in that locality. Some things that I've seen are restrictions to the number of hens, setbacks for coops and pens, the number of roosters, if they're allowed at all. New York City, no roosters. Sometimes I've seen neighbor consent must be made, pest control, feed storage, beekeeping. Again, local zoning ordinances, this is what we're looking at. In New York City, for example, beekeeping is legal. Apiaries used to be, or bees used to be considered wild animals, and wild animals are prohibited in New York City, but the law recently changed in this area for the last few years. Notably in New York, beekeepers may still be subject to tort liability. And over the next few slides, what I'm going to do is go through some examples of New York ordinances dealing with urban agriculture. I actually pulled these from a great resource that was, again, no surprise here, found with the Cornell Cooperative Extension Small Farms Program, but it's titled Guide to Urban Farming. And I'm at number 29. It's not page 29, but it's at topic number 29 in the publication. Let's look at Albany. Albany says no livestock, blanket prohibition. Buffalo, on the other hand, they say you can have chickens, but no more than 5. It can't be in a multifamily complex. You have to have express written consent of all the residences that reside on a property adjacent to the applicant. You can't make any money. They're only for personal use. No roosters are allowed. The chickens are restricted to the rear of the backyard. And you need to have a license and pay $25. This is what Buffalo says. You also say no cows, goats, horses, pigs, or sheep. No surprise there. Let's look at Geneva. Geneva says no bees, no apiaries. It's a nuisance. If you can remember back from your first year of law school, it's actually going to be a nuisance per se, right? Because it's a nuisance here under the law. Geneva says, but will allow chickens, ducks, geese, and other fowl so long as it is in an agriculture residential use district. That is different than the agriculture districts that we just talked about with the right to farm law. So try to distinguish those in your head. This is dealing with zoning law, okay? But with other types, cattle, horses, and sheep, they may be kept, again, if it's an agriculture district, so long as they're in clean and sanitary conditions, and you must clean your barn once every 24 hours. But no goats, pigs, or swine. All right, New Rochelle. What does New Rochelle do? This statute was a little bit more ambiguous. And the whole point of this is also just to kind of show you the differences in the localities in this area. So it says, no equine, that's horses, for those of you that don't know, swine, bovine, which means cattle, ruminant and avian species. Another example of a ruminant animal is sheep, goats, on parcels of land with inadequate size and setbacks within the jurisdiction of the city of Rochelle that cause offensive odors which interfere with the quality of life and public health. Okay, what does that mean? I'm not really sure. But that's an example of, you know, a more ambiguous local ordinance in dealing with urban agriculture. North Tonawanda says it shall be unlawful to harbor and maintain any animals or livestock. This does not apply to slaughterhouses, which I thought that was an interesting exemption. Rochester says no live animals, except animals for show or exposition purposes only. What does this mean? A cattle show, a horse show. So people that are coming into Rochester just for a show only and then leaving, that would be an exemption here of livestock that is allowed in Rochester. Looks like they have a poultry license for people that want to raise chickens, geese, ducks, doves, pigeons, turkeys, and other types of animal or fowl. And so I thought that was interesting. Moving on to Syracuse, and I know this is getting probably a little tedious. We'll try to move through this. But I especially thought this was the most interesting because they say no reptile, bird, or animal which is wild, ferocious, fierce, dangerous, poisonous, or naturally inclined to do harm. And then later on, in the next section of the statute, it says that wild, ferocious, fierce, dangerous, and poisonous animals, birds, and reptiles are defined to include cows, guinea hens, goats, sheep, and swine. For those of you that are friends with me on Twitter or Instagram or Facebook, there's a picture of me riding a cow. I was very young, I was only 2 years old, but my experience in being around cattle is they can be very docile. And you know, goats and sheep can also be very docile. Swine can be very docile. Some aren't. I've been around some angry boars, okay? But I thought that was very interesting that Syracuse says that cows, guinea hens, goats, sheep, and swine are inherently wild, ferocious, fierce, and naturally inclined to do harm. And I'm going to disagree with the Syracuse locality on that. White Plains, no live chickens, geese, ducks, or other fowl shall be kept in the city unless they are securely enclosed in a manner as to prevent them from straying from the premises of the person owning them. All right, we'll go ahead and move on to the last topic today, which is volunteer farm labor, which is a very important legal issue for the local food movement. It's a big deal. A lot of farms who are involved in direct farm marketing use volunteer labor in some way. Specifically, what I'm going to be talking about today are compensated volunteers or just straight up community volunteers that are not going to be compensated. So we're going to really delve into farm employees per se, but as we'll talk about, that line is a little blurry. So what are the types of volunteer labor that's typically found on farms in CSA? Well, one would be a work share or half work share. I'm going to take a step back for those of you that are listening today and we're not able to listen to part one of this series. A CSA is an abbreviation for Community Supported Agriculture. I was in a CSA on the Upper West Side where I reside in Manhattan. I paid a certain amount of money for a half share of both fruit and vegetables. And CSAs are kind of a hot trend, I think, in the local food movement where people pay money for a share or a subscription and they go every week or maybe every other week and they pick up the produce. And there are also different kinds of CSAs. There are meat and dairy CSAs. I have a friend in Philadelphia that's in a pie CSA. So that's what we're talking about with CSAs. Sometimes these CSAs require people to work. They volunteer on the farm. And perhaps they're required to just do that, or perhaps what they do in exchange, they're able to get their share for no cost or reduced cost. So that is what a worker share or half work share is. Travel-based volunteers, woofers would be an example of this. I have a friend of mine in New York City who got tired of being a lawyer one day and he packed up his suitcase and he moved to France and he lived on a farm for a whole summer and he picked fruit and he got free shelter and free food every single day, and that's what he did for a couple months while he thought about his next steps in life. That's one example. I also have some students at NYU that have done this in various summers, and it's like a whole culture out there of people from all over the world that are traveling to go work on farms. So travel-based volunteers. Informal worker shares. An example of this might be with my CSA. They're not requiring me to volunteer for 4 hours on a Saturday every Saturday during the entire growing season, but they did ask me to volunteer a shift or two to help with the CSA. So that might be an example. And then casual volunteers. Like I have some friends who have rooftop farms. They occasionally have some friends over and they give them some beer and they just come and pick weeds for an afternoon. So that might be some more casual volunteers. No regular commitment. They're not agreeing to come every single Saturday, but when they have time, they'll swing by. Why is this all important? Well, there's a statute called the Fair Labor Standards Act, which sets forth minimum wage requirements. And employees under the Fair Labor Standards Act need to be paid minimum wage. So are these volunteers on the farm, are they an employee and should therefore be paid minimum wage, or are they a volunteer? Now, when I say they should be paid minimum wage, that doesn't mean that when they receive an $800 CSA share in exchange for their time, that they're not being paid. They are actually getting paid, but it's called in-kind compensation. They're being paid in food right? Or maybe they're being paid in shelter, combination of both. But the first question here is whether the minimum wage requirement applies to these compensated farm volunteers. I wish I could tell you that the law in this area is straightforward, but it's really not. It's actually quite complicated. And Rachel Armstrong, who I believe she's in Wisconsin with Farm Commons, she has done a fantastic job researching this area. I recently moderated about 8 and 9 months ago for the American Bar Association a CLE on employment and labor law issues for farms and ranches. And Rachel Armstrong did a great job talking about this. There's some substantive materials in that CLE. If you want some more information on this specifically, I recommend talking about that. But put simply, the court's going to ask the following questions in deciding whether or not that the volunteer is truly a volunteer, or whether or not, for the Fair Labor Standards Act, whether they should be considered an employee. One question is the volunteer working in expectation of compensation? Maybe the expectation of compensation is really just food. Maybe it's shelter. But is there some kind of an expectation for compensation? Is the volunteer displacing employees? Is the farm not hiring people to work because they have community volunteers that are there working? Does the volunteer give the food business a competitive advantage? And is the farm offering educational benefits? And this looks a little bit more like an internship, and there are specific factors on whether or not it is an internship, but the question here is really who's benefiting? Is it the person that's volunteering on the farm receiving the educational benefits, or is it the farm employer who is getting the volunteer farm labor? There is a big exception, though, under the Fair Labor Standards Act, and that is this 500 man-day exemption, which states that a farm utilizes fewer than 500 man-days of labor in any calendar quarter of the previous year, then they are exempt from federal minimum wage requirements. So even if a farm is really, these volunteers are really considered employees under the Fair Labor Standards Act, if the farm is utilizing fewer than these 500 man-days, then they're still exempt. Don't have to worry about federal minimum wage. If the volunteers are considered employees, and they contribute, though, to this man-day calculation. Some concerns with using volunteer farm labor with insurance are workers' compensation. Volunteers may not be covered under workers' compensation. And most farms, and in my last lecture that I gave here at Lawline, I talked about liability and liability insurance. And one of the types of insurance that I spoke about was the farm owner's liability insurance, right? And no employees are covered under that insurance policy. So if the compensated volunteers are considered to be employees, then if they get hurt on the farm, they're not going to be covered under the farm owner's insurance. But commercial insurance will likely cover unpaid volunteers, but not compensated farm volunteers. It's a mess, right? It's a little bit of a mess. And I really suggest there are some great publications online about this. Fair Grange Law, I think that they're in Minnesota. They've done some, Jennifer Jambor, she and her partner have done a great job writing some excellent publications kind of dissecting all the farm labor and employment law issues as it applies to volunteer farm labor. Because of time, I'm not going to go into any more detail today, but I think a lot of farms now are having questions on employment and labor law issues. For those of you that are listening today that are agricultural lawyers, I think it behooves all of you to say, just because a lot of farms now are using volunteer farm labor, it doesn't mean that they're doing it correctly. And maybe we need to take a step back here and make sure that proper record keeping is taking place to ensure that they're fitting into that 500 man-day exemption, or if there's in-kind compensation, that these people are really being compensated at least minimum wage for their time on the farm. If you have more questions about being an agricultural lawyer, I actually have Fridays with Carrie Skype calls on the first Friday of the month at 2 p.m. Eastern Time, every single month. If you want to join next month's conversation, go ahead and just email me at Carrie@Rinker Law. There's no charge for this. As I noted before, I recently wrote a book on New York food and agricultural law. It's available for sale on Amazon.com. I do talk a lot about New York law issues, but there are a lot of just general issues that I speak about as well. It's geared toward the non-lawyer reader, farmers and food entrepreneurs, but I think it is also a helpful resource for attorneys as well. And here are the myriad of ways if you would like to contact me. Send me mail the old-fashioned way, call me, email me, tweet me, Facebook me, find me on LinkedIn, and occasionally you might find me on Skype. Thank you very much for your attention today, and good luck to you.